Thank you, my lady. Carrying on from where I paused, in a nutshell, further events. Back in the bedroom of the hotel, room 221, there was a flurry of argumentation and exchange of SMSs or WhatsApps or whatever those messages are called between the deceased and Miss or Mrs. Alterskaya, and it seems as if there was a particularly graphic exchange, something in the vicinity of just after 7 o'clock in the morning. As per the court's judgment, this culminated in the conduct of the deceased, in what I can only describe as a moment of madness or weakness on the part of him, in which he simply snapped, and the court found that he punched the deceased on her eyebrow, that he exerted force on her to immobilize her, that he throttled her, and that he smothered her with a pillow. One thing I can say, and that is something I will deal with later when dealing with the personal aspects relating to the accused, as unacceptable as that conduct might have been, by the same token, it was totally out of character. Now, so much for the nature of the crime of murder. On the basis of the court's judgment, the accused thereafter attempted to conceal his evil act and the commission of the crime of murder by staging his wife's apparent suicide. And whilst obviously unacceptable, he was convicted of obstructing or defeating the administration of justice in this regard. I do submit that the seriousness of that crime can never stand to be approximating that of murder. And so we turn to the needs and the wishes of society in response to crimes such as this one, and in particular those crimes in respect of which the accused has been convicted. We never argue that society condones such conduct or views it in any other than a most serious and severe light. I also accept the testimony inter alia of Dr. Abrams that interpartner violence, and in particular intimate femicide, constitutes a serious societal problem throughout the world, but in particular in South Africa, and that our society will not accept or tolerate such conduct. I don't think much more can be made of the testimony of Dr. Abrams, but she was clearly an expert in that field. Looking at it from a slightly different perspective, we have the testimony of Mr. Perry, which of course was entirely based on hearsay, that this death constituted a devastating occurrence affecting the lives of all involved and affected parties. What is required, of course, is a balanced approach that takes into account all appropriate factors in a fair and just manner. And this brings me to the personal circumstances which constitute the most important and integral aspect of the sentencing process, the personal circumstances of the accused. I think it's fair to say that the crime of which he was committed would fall into the category of a crime of passion. I I have already dealt with the nature of the murder, and I'm not going to go through all of that again. And the court heard at some length when the accused himself testified regarding his personal circumstances, his background, his perception of his relationship with his wife, and his upbringing. And we also heard great detail in that regard from his devoted mother, who testified here the other day. Essentially what we're looking at is the following. Although his biological father left the scene when he was very, very young, for all practical purposes, he was brought up by his mother and her present husband, been married for 46 years, and he was adopted by his father, and an absolute father and son relationship of the top drawer existed and still exists between them. So essentially, we're talking about a loving father and a son who cares for his father. We're talking about someone who was brought up in what was obviously a middle to upper class home in the north of Johannesburg, which constituted obviously a stable home, a stable marriage, and he was brought up in circumstances which were very favorable and stable. At a later stage, when he was 9 or 10 or thereabouts, his mother gave birth to her second child. There was quite a gap between him and his sister. However, he proved himself to be a good brother, a kind, caring, and devoted sibling who played an important role in a family setup where his sister suffered from a severe disability, namely that of being completely deaf. And he played his role there without any vestige of a suggestion of criticism at all against him. And so he grew up, he went to a junior school. There were no serious problems with him. There were no birthing problems. There were no milestone problems in terms of progression through infancy. He was a successful scholar at junior school. He played his sport with great dedication. He loved his cricket. He was captain of the school's cricket team. And he did fine academically, although it was subject to the rider that, according to his teachers, a little bit more application and input would see him doing far better. He went to high school, well-known, famous school in Johannesburg, where he succeeded academically, passed all his years, made a lot of friends, socialized very easily, played all the sports, preferring, I think, now rugby, and passed his matriculation with a university admission level of qualification. One interesting feature of his schooling, both his junior schooling and his high schooling that emerged, is that to this day, and just to put that in perspective, he is now 50. He turned 50 in prison, in fact, last month. To this day, he has retained a vast number of friendships and friends, even from his junior school and high school days. He is a person who makes friends easily, who socializes well, and is socially well adjusted. Now, another feature that emerged was that There were no issues at any stage during his early upbringing, and in fact at any stage thereafter, involving unacceptable, dishonest, violent, aggressive, or any similar form of unacceptable or misconduct. So we have someone who went through life until he passed his matric in a normal way, doing well, although academically he could have performed a bit better with a bit of more hard work, but a good member of society. He then once again did well. He was obliged to perform national service for 2 years at that time, and he elected to do that straight away to get it behind him, and he did well in the national service, attaining the officer of the rank of officer. Thereafter he went to university and was busy with his second academic year when he met his wife, the deceased, who, although South African, at that time, as I understand it, her parents were living in the United States of America, and she came to South Africa to visit, and he met her, and one thing led to another. I mean, in terms of a relationship developing between them, and he elected to chuck up his university studies and go into the business world because he wanted to start earning and making progress in life. He worked in various occupations, as we've heard from his mother, and then ultimately he and his wife, through a family permanent residency program of Australia, elected to join her parents in Australia, and incidentally at that stage her sister and his husband and her brother-in-law in Australia, and they emigrated to Australia. This of course explains why, having been born in Birmingham, the United Kingdom, having been naturalized in South Africa and having then moved to Australia, why he was in possession of 3 passports from those 3 countries, and it is a matter of record that he did so with the consent of this government. He worked in the estate agency business in Australia for a couple of years, and it seems as if things went very well and very successfully in the business side of things. It seems as if his wife was very happy in Australia, and she was close to her sibling and parents, and probably her brother, who, as I understand it, was also there and who testified. But he missed his friends and he missed South Africa. And eventually he and his wife returned to South Africa, and here he started and set himself up in the estate agency business. He must be a man of intelligence, and he must be a man gifted with business acumen, because he did extremely well in the business, in the realty business, and eventually became involved as a third shareholder together with his mother and another woman partner in establishing an estate agency in the northern suburbs of Johannesburg, Dainfern, I believe, with the name of Glasshouse Realty Proprietary Limited. Clearly that company worked and operated very well. The division of labor involved him making management, staff and accounting and business decisions, with his mother and her partner being predominantly involved in the sales. And this business progressed well, and it reached the stage when it was approached by the large national franchise group Lou Geffen Estates trading as Sotheby's to become a franchisee. However, Mr. Rohde was aware of the perils of the entanglements of a franchise and refused to do that, and eventually a business deal was reached in terms of which Mr. Geffen became a quarter shareholder in Glasshouse, and Glasshouse attained all the branding rights associated with Sotheby's, but without the burden of being a franchise and all the obligations associated with that. And this business progressed extremely well with a new branding. And then it happened that the CEO of Sotheby's left unexpectedly, and Mr. Geffen was looking for a new CEO, and he invited the accused to take up the position, which he did. And from then onwards, he had the dual occupation of being the CEO of Sotheby's in the entire Southern Africa, plus retaining his shareholding, or quarter shareholding at any rate, in Glasshouse and his involvement in that business. And quite clearly he did extremely well. In the meantime, he and his wife had years before that battled to have children, and then through a local Cape Town IVF program, she fell pregnant with her first child, and then a year or two later with a second child, in fact with the twins. And so by the time 2015 came along, you had a relationship between the accused and his wife that was of many years' duration, involving also, as it did, 3 daughters, 2 of whom went initially to school in Johannesburg, and the other twin was in boarding school. It is quite clear that during the period subsequent to leaving university and giving up his BCom studies and 2016, that Jason Rohde, the accused, continued in terms of forging good, deep, and warm personal relationships with people. We've seen that from the 2 witnesses who testified as just an example. A person who made friends, who kept friends, who retained friends, and who has been described as a friend indeed. As they say, a friend in need is a friend indeed. And he was that sort of person. No significant history in terms of aberrant behavior or psychological problems or anything along those lines. No history whatsoever throughout his life, and this is a feature which I really wish to emphasize, and that is, this aspect was explored to the bone. There was not one vestige of a suggestion of any physical violence ever having been perpetrated at any stage by the accused, whether towards his wife or anyone else. That is one allegation that has never been demonstrated and clearly did not occur. There was a suggestion from the state pathologist, Dr. Katsiat Khan, that the wife might fall within the category of a battered wife syndrome, And that was utterly dispelled. And in fact, it was through the affidavits of the deceased's mother and sister that it was established that the large healing bruises that she had on her upper legs had been occasioned by a fall that she had whilst practicing in her home gym and landed on some dumbbells and hurt herself. No violence whatsoever. Never once.
Except, sorry, Mr. Van Spey, except of course on the Saturday of that weekend, or rather the early hours of Sunday morning.
Prior to that, nothing whatsoever. Now we'll get to that. And so it's against this background that, and I think it's fair to say that this relationship, this marriage relationship between Mr. Rohde and his late wife was one that had its ups and its downs over the years. And they certainly had very different personalities. The general approach to a situation on the part of the deceased was to confront it, to be in your face, to want to talk it through, to want to deal with it, to want to solve it, to want to overwhelm it, to come back to it, to repeat, to come back again. Whereas the general approach of the accused to all situations involving any form of confrontation was rather to back off and to back away and to move away from it, to avoid confrontation. Violent confrontation didn't enter into the picture in any context, whether social, business, family or whatever. And it must just be mentioned that and emphasized that the deceased treaded along life's path, doing well, making people happy, employing people, giving them work, making it possible for them to earn incomes, and generally traveling through life without really many hiccups, without any problems, and for 48 years with an absolutely, completely and utterly clean record in terms of any crimes or misdemeanors. Now you have heard the testimony of Mr. Livingston, Mr. Craig Fleischer. I don't intend to repeat it. It's still very much in the forefront of my recollection, what they had to say about him. But there's just two factors that came out of their testimony that I did find particularly appealing to me. And before I met them and consulted with them, I did not know about these things. They were not told to me by the accused himself. One was an example of him putting his maidservants, his domestic servants' grandchild through her educational program, through schooling, etc., etc. And at the moment, I think they said she was about to graduate with her master's degree. Never told that, mentioned it. It took somebody else to mention that for us to find out about that. And in terms of playing a commendable role in society, I believe that that sort of conduct goes above and beyond the call of duty. And what a pity all South Africans are not like that, where they have the means. And the second facet arising from that was the evidence that he was always friendly and available towards his friends and colleagues with sound business, marketing and financial advice. He even assisted them in that regard where the need arose. And incidentally, Mr. Fleischauer particularly mentioned another aspect, or it might have been Mr. Livingston. It doesn't really matter which one of them mentioned it, that he took it upon himself, and I'm not saying that his wife wasn't equally involved and stands also equally to be commended, and that is to take a poor underprivileged child from Johannesburg, fly her down for a full-scale holiday for 3 weeks in Plettenberg Bay, all expenses paid. That takes some doing. And that is the type of person that we're dealing with. The accused's 3 daughters have not been available in court as witnesses, but we do know from every single available source, from Mr. Perry's report to the grandmother's report, Mrs. Rohde, to the friends who've testified, of the very, very close relationship. Even now, even since the death of their mother, between the daughters and Mr. Rohde. I can mention that Mr. Rohde would not allow us to meet or consult with or involve his 2 daughters who were in matric in any measure whatsoever in this case prior to their completing their matriculation examinations. Essentially, he sought to look after them, to protect them, and to avoid any contamination which they might suffer from a too close involvement in this case. I now turn to briefly to the testimony of the specialist psychiatrist, Dr. Stoloff. Now, he started to treat the accused for depression a month or so after the death of his wife, and Mr. Rohde has remained under his treatment until the present time. I'm not exactly sure how matters work out for a person who's in prison, whether they can still see a private psychiatrist or not, but in any event, until the time when he was incarcerated and his bail was withdrawn, Dr. Stoloff was actively involved in his treatment. In particular, Dr. Stoloff was actively involved in hospitalizing him during, or about, the exact date's not so important I suppose, about the 4th of February 2018, when he suffered a major depressive episode and was considered to be seriously at risk of committing suicide. And Dr. Stoloff has assessed him repeatedly, and he's done so on his own evidence in the context of a team approach at Crescent Clinic or Kenilworth Clinic, wherever they were, involving him as a specialist psychiatrist, involving a clinical psychologist, involving physiotherapists, occupational therapists, and dedicated psychiatric nurses. And what emerges from this is the following, and this is uncontradicted evidence. The accused has no personality disorders. And I'm talking now things like bipolar disorder, antisocial personality disorder, psychopathy, borderline personality. None of those are present with him. He is most certainly a candidate for depression. He is still depressed, even as he sits here and he will require treatment for a long time, and it might be expected that there will be flare-ups involving major depressive episodes, which involve higher risk and everything that entails. Anxiety also plays a role. Now, I did mention at the beginning of this case that I can't come and argue that my client is remorseful for having killed his wife, for obvious reasons. But what I can say is it's quite clear from the testimony of this specialist psychiatrist that Mr. Rohde has huge remorse involved in the death of his wife. He articulated that when he testified, that he blamed himself for her death in the sense that it was his misconduct that caused her to commit suicide. In a phone call to her brother, he repeatedly stated, "I killed her, I killed her, I killed her," meaning, and of course, and being interpreted as meaning that his conduct in being unfaithful had led directly to his death. He also said that he would, for the rest of his life, carry the burden of the guilt of his wife's death on that basis. Now, there certainly is remorse on his part in respect of his conduct. Now, to sum up, we have somebody who has grown up in what I suppose I could describe as the middle to upper middle class stratum of Johannesburg society. He must have done well financially. A mild-mannered, well-organized, intelligent man who went through his entire life with a clear record, with an exemplary background, and in terms of his achievements in life, family and occupation-wise, probably somebody who would be envied by many people. And socially, I mean, in terms of his social reactions. A history of complete and utter non-violence in the marriage context, and we have many records to confirm that, including, if I recollect, the testimony of Sergeant Apollos, or maybe Sergeant Adams, I can not always remember who went and specially interviewed the domestic servant, Lucy, to find out, is there any dirty linen to be scratched out here, and who gave the assurance that physical violence and aggression did not happen. She had never observed that in the marriage. And that is the general evidence that we've got. There's no reason not to believe that. And in fact, it was also confirmed by the members of the deceased's family who testified. Her brother from Australia and Mr. Norton confirmed that. We have a person who was torn between his emotions and desires in terms of his infidelity on the one hand, and his marriage and his children on the other hand. He very, very dearly loved and still does love his daughters, and as dependent as he was on them, so were they dependent on him. He was, incidentally, for all practical purposes, the only breadwinner in that family. I've dealt with his work. I want to deal with one aspect which I feel deserves to be highlighted, and that is that from the absolute outset in regard to this matter, from the time of the involvement of the South African police on the 24th of July, Sunday morning, 2016, nothing but total and utter cooperation was given by the accused. Voluntarily, although being advised not to do so by his in-laws, he wrote out a handwritten statement on the day of her death and gave it to the police voluntarily. He made himself available on that day to be examined by the district surgeon to see whether he had any injuries, and the district surgeon cancelled the consultation. His hands and forearms were physically examined by his father-in-law, who found no injury or problem. He was asked by the police to surrender his passports. He did so absolutely voluntarily and without having been pushed to do so. He was requested by the police to fly down from Johannesburg to Spier to demonstrate to them exactly what, according to him, had occurred leading up to his wife's death, and he climbed on the plane and met his attorney at Cape Town Airport, only to be told, and I don't believe this, that Spier refused to let the police visit the scene of the incident.
Sorry to stop you, Mr. Van Spaan. I read the transcript of the bail proceedings. Just on the issue of the passport, just for clarification, I seem to recall that Mr. Rohde undertook through his representatives to surrender his passport, but it never happened until he was arrested. And then after that, whilst he was 6-7 days in custody, the passports were handed into the Stellenbosch police station. I'm not sure. I think that came out of the transcript during the lower court proceeding. Do you know details around the
My lady,
passport?
I wasn't part of the team at that stage, and I can't recall picking up on that in the transcript, but if the court would give me some time when I finished here, I'll take instructions on that point. I think the point that I'm trying to make is that his passports were handed in voluntarily, and contrary to a suggestion that was made, he never made any attempt to skip the country or to move funds out of the country, aspects which were fully investigated and found to be absolutely without any merit. And that was the point I was trying to make. He was asked by the police to, in the failure of the visit to Spier, to surrender himself for a medical examination by Dr. Timmensma in Victoria Hospital, if I remember correctly, a state forensic pathologist, and he went and did that immediately. He was accompanied by his attorney to her rooms, but not obviously in the examination. And I do submit that at every turn of the road, he has given his cooperation. I also submit that the same applies to the proceedings since he was first arraigned and arrested and granted bail. Now, I thought I would pause for a moment, having visited my client at Baltimore Prison and having been quite aghast by what I observed and saw, that I would pause for a moment and consider what it involves to have a period of imprisonment imposed upon one if you're a person in the position of the accused. You're obviously used to a reasonably luxurious, or let's put it this way, comfortable lifestyle. If you want to pop down to a local restaurant for a meal, you don't have to turn over the money in your pocket to know whether you can afford it. You can do that. If you want to play a game of golf, you can do that. If you want to socialize, if you want to go on holiday, and overnight, all of those freedoms and all of those all of those liberties are totally and utterly removed from your life. You can't anymore even just sit and watch TV. You can't even anymore sit in silence. When I visited the prison, the noise there was, the deafening noise was something which absolutely astonished me. The financial implications at the age of 50, to be cut adrift from your ability to work. Now let's just forget for a moment the devastating financial implications of trying to work whilst you're on bail and running a trial whilst you're defending yourself, and the expenses associated with a myriad of factors in such a trial. A trial like that is financially devastating. It involves an enormous financial loss. But the long-term implications of a jail sentence are, of course, from a financial point of view, even more serious. Let us just postulate for a moment, and I'm not suggesting this, let's just postulate for a moment that a sentence of the minimum period of 15 years is imposed upon my client. He'll start his sentence at the age of 50. He'll come out when he's 65. His life is past. There's no prospect whatsoever of getting a business up and running at the age of 65 or thereafter, when you've been out of circulation for such a period. Maybe that can be shortened with good conduct and remission. I'm not sure how those things work, parole and all that. But the fact of the matter is, as things presently stand, the minute he was charged, in this case, he was fired by Sotheby's, so he lost that huge appointment. There's a battle at Glasshouse at the moment. His mother, who is I think she said she was 68 or thereabouts, but in that vicinity. She's the youngest partner there. And she and her partner are involved in sales, don't know anything about business, marketing, administration, accounting, staff issues. That business is going to take a knock, whichever way you look at it. And it's going to affect the employment of 25 people. Let's look at the financial implications for the children. My learned friend produced some document which indicated that some policy absolutely unknown to us of Liberty Life paid the estate something in the order of 700,000 rand. Fine. For how long can you educate children for that amount? We had the figures last time. It costs 100,000 rand plus per child per year. That's what we're looking at. It is not possible to say that this crime, that this conviction and the sentence that will be imposed is not going to have a devastating effect on the children. They've already lost the house in Johannesburg. that it be sold for various reasons. And as I understand it, incidentally, their only true home at the moment is the Plettenberg Bay property, which was previously treated as a holiday home. That is their only home now. And so, from being a person in the prime of his life with an unblemished record, a moment of madness in which an accused person snaps and acts very much out of character, has turned into a nightmare. Not sure if the court ever saw a film, I can't remember its name now actually, it involved an act of infidelity, and it really highlighted the extreme consequences that can flow from such stupid conduct. But in any event, whatever my learned colleague might submit, the financial implications and the personal and social implications for the children are going to be adverse and very bad. The daughters, as I have it, are presently 20 and 18 years old, the two youngest ones. My client is going to miss their early years and relationships. He's going to be sitting in jail when they get married, probably, when they have children, and when they're in the prime of their lives. He's not going to enjoy it. And they're not going to enjoy him. They won't get any financial support from him. They won't be able to get emotional support from him to the extent that he's incarcerated.
I just wanted to ask if I understand your argument correctly. You pointed out quite in detail that Mr. Rohde was financially fortunate, largely through his own hard work, and that is the converse of what he would be experiencing in prison. Is that intended to be a mitigating factor? Because what happens when I have to sentence someone who's underprivileged?
What I'm
suggestion that it's easier for them to prison?
No. I'm not suggesting that an underprivileged person suffers less or is less affected by a penalty or a sentence, although it could also be a case of how the mighty fallen. This court is obliged to impose a minimum sentence of 15 years imprisonment for the murder charge, unless substantial and compelling circumstances are present.
It can be cumulatively too. It doesn't have to exist in one particular factor. So
Thank you.
I can take that.
Thank you, my lady. And I have observed the points raised in this judgment of my learned, of my lady's fellow learned ladyship. I believe that the cumulative effect of the following aspects do constitute, in the present case, substantial and compelling circumstances that justify a departure from the minimum and, in fact, a reduction. At the top of the list is the question of the children, their social, their familial, and their financial needs seem to me to be of a major importance. And every extra year that the deceased, accused spends in jail detracts from his ability to give what they need to his children in that regard.
I ironically also the same applies for the deceased.
The same applies?
For the deceased. If for every year that she's absent, they suffer social, familial, and financial.
This matter is a tragedy from A to Z. Another factor that seems to me to be compelling, and my lady, I will get to dealing with 4 or 5 of the aggravating points in a moment, and I'm nearly finished. Got half a page to go. Seems to me to be the level or category of murder. It sounds callous to be talking like this because I accept murder is murder. But as I dealt with different levels of severeness and severity and seriousness, and I do submit that regard being had to the particular facts of this case, this is low on the level.
Well, that has already been recognized by the legislature, and for that reason, the category of murder, I should call it, in this particular case, attracts the prescribed minimum sentence of 15 years.
But
without considering, of course, aggravating features, which allows me to exceed, and of course, substantial and compelling factors, which allows me to deviate any further this sentence. But as far as categorizing it is concerned, the legislature has done that.
But I do believe, my lady, it must be a compelling circumstance. The fact that in causing his wife's death, the accused acted totally out of character, in a moment of weakness, and in the context of a passionate response to a circumstance. He did not act out of an inherent evilness or personality disorder, nor was he motivated in any manner by malice or vice. His conduct was completely out of character. I also submit that if one takes into account the circumstances actually portrayed in this Mathetwa case, where the question of substantial and compelling circumstances stood to be considered, and the issue of aggravating circumstances, and obviously the whole issue needs to be balanced. And in that particular case, the court said no. You can take into account, as the court has now said, the cumulative effect of various factors. And my lady, I'm not going to repeat everything that I've now said. But that taking that into account, on the other hand, taking aggravating circumstances into account, the learned ladyship felt that a sentence in excess of 15 years was appropriate. And she imposed, as I understand it, a sentence of 18 years. But what I would like to highlight is the following. She says the following. The aggravating features of the crime are overwhelming. The victim was a defenseless woman and the attack was unprovoked. The victim thus posed no threat, and the evidence shows that she had alcohol in her system which lowered her defenses. The attack occurred in the early hours of the morning, and it is common cause that the deceased was a sex worker, and this fact multiplied her vulnerability. Now, this seems to me to be particularly important. The appellant left a lounge, or the corner lounge, on this particular night. He went home, and after about 1 hour and 10 minutes, left for Ravenscraig Road, where he committed this horrific deed. He had ample time to reflect while he was at home, but he was determined to confront the deceased and proceeded to execute this horrific attack. The appellant kicked the victim more than 60 times. He paused in between the attack and elected to continue between pauses. His conduct during the attack in kicking the deceased to the head, the face and the body, and the manner in which he conducted himself during this attack by lifting the body of the deceased is indicative of his disrespect for the bodily integrity of the deceased. A further aggravating factor is the serious nature of the injuries sustained by the deceased. She suffered a total liver injury. The liver was virtually torn in half through the lobes. She had various rib fractures and abrasions as well as blunt force injuries to the face. Now, it seems to be a very difficult exercise to compare the levels of violence involved in murdering somebody, because obviously by the nature of things, if you murder somebody, you have to bring to bear on the matter a level of violence that is sufficient to cause death. But I do submit that if you compare the court's findings relating to the conduct of the accused in the present case with what we read here, then there is no comparison in terms of the level of violence involved. Also, the absence of going away and coming back and one could almost say almost planning the violence here. That isn't an issue in the present case. In the case of Mteto, it doesn't seem as if we were talking about an act when a person had enough and just snapped. And if those circumstances justify an increase of 3 years, then I would submit that in the present case there is no basis for suggesting more than 15 years, and in fact that there are substantial and compelling circumstances justifying less than that. I want to deal with...
Sorry, just to stop you there, you have now gone into the terrain of dealing with aggravating features. But in particular, I wanted to raise with you, and I deliberately didn't raise it with Mr. Panika, because this is now in your terrain. Mrs. Rohde did not die instantly.
She did not
die instantly. I think all the experts were unanimous about that.
She didn't die?
She did not die instantly. She suffered. She suffered a painful and gruesome death. The injuries over her body was inflicted in an egregious, gratuitous manner.
My lady,
you were on the point of aggravating features now, so I'm pointing that out. I would like you to address that when you are dealing with the issues of exceeding the minimum sentence.
My lady, and I say this with great respect, all the experts are not ad idem on that point. If the court is indicating the state pathologists are ad idem on that point, then I will
Yes,
concur.
I'm referring obviously to the state pathologists insofar as they were able to testify and give account as to the duration it took for her to succumb to death.
But even if one were, for the sake of argument, to accept the testimony of Dr. Abrahams, then on her basis, and I just hasten to add that scientifically I have difficulty in that proposition, but on her
Let's go to the court's finding. The court's finding was she suffered. The court's finding was that the pillow that she was suffocated with had seepage of her wound above her eyebrow, and it came with twice on that pillow, which is the sign of having been suffocated repeatedly. It's repeating action pushed onto her face.
But there is no evidence or indication that any suffering occurred over a lengthy period of time on the part of the accused, the deceased, even on the court's version. Compare that with a situation where a man kicks this woman 60 times, for heaven's sake.
Let's not go back to that case. I'll tell you why. Because every case turns on its own unique facts and circumstances. So whilst there might be factors that overlap, This is Mr. Rohde with his wife, Mrs. Rohde, in their bedroom.
Well, can I deal with the other aggravating factors?
Sure.
My colleague here said that one of the aggravating factors is that the deceased was cut down in the prime of her life. Now, my lady, I have my doubts about that as an aggravating factor. I'm not saying she wasn't cut down in the prime of her life. And if I were a mendacious person with an evil intent who planned her murder and systematically carried it out, then that would be a valid aggravating point. But with the greatest of respect, in the context of the conduct of somebody who has an absolutely 100% history of non-violence and who snaps and loses control of himself, the last thing you can count as an aggravating factor is that he has cut someone down in the prime of their life. Because he doesn't have time to think about that when he acts. And in any event, surely any murder, per definition, involves, to a greater or a lesser extent, cutting someone down in the prime of their life. Whether it's a child, whether it's a 25-year-old, whether it's a 50-year-old, or whether it's a granny. The next point is, my learned friend, and I'm not sure that the court, I think the court didn't accept this argument, but he regards it as an aggravating factor on the charge of murder that the accused staged thereafter the suicide. I cannot accept that that is an aggravating factor, and I'm not going to argue that any further.
Aggravation in regard to count 2 itself, but I will not consider it an aggravating factor when I consider the minimum sentence expected murder.
Right. And I'm not sure that it's an aggravating factor in regard to count 2, because that is count 2. That is what he did. That is the fact that is alleged, that he staged a suicide.
The court's with you on that.
My learned friend argued that a further point of aggravation was that this occurred in the sanctity and safety of the bedroom, and that the accused never commenced divorce proceedings prior to that. Now, I'm not sure that I buy into that argument. I don't think it makes it any less excusable or more excusable or morally more acceptable if I murder my wife on the street corner as opposed to in the house where we live. They're both utterly unacceptable. What I would say is that I'm prepared to concede that there is a relationship of trust between a husband and a wife, and that would be an aggravating factor. The issue of intimate femicide, being an aggravating factor, I believe, with the greatest respect, is once again misconstrued. I'm not saying that intimate partner femicide is not a problem. I acknowledge that it is a problem. But once again, where a person acts out of control and on the spur of the moment and snaps, that's one thing. When there's a history of violence between him and his wife, and it accumulates in 1 million cuts, scratches, bruises, hospitalizations, battered wife syndrome over a period of time, and it culminates in a murder, that would be aggravating.
Are you saying femicide requires a prior history of violence?
Well, if one looks incidentally at the authorities that were produced, and in particular the main authority that was alluded to by Dr. Abrams, then the pattern or the what is the word? The sort of characteristic traits of the perpetrators of intimate partner femicide do have that history. There is a history of violence. There is accumulated history of disrespect and so on and so forth.
I recall reading that. There were about 20 or 40 people they interviewed, and some, it was found that had not displayed violence to their partners up until the moment that they killed their partner.
My lady, my understanding is that, now I don't have that article with me presently, my understanding is that they interviewed approximately 40 convicted murderers who were involved in murdering their intimate partners or wives or whatever, and they tried to establish the common threads, the common denominators. I do not recall that a characteristic that came through was an absence of violence between the partners before that. Do not recall that.
I recall that. It wasn't, it's not a sine qua non. It has happened that physical violence, there wasn't a history of physical violence, but that when the murder happened, obviously violence took shape to fatal consequences. But let's not get stuck on that. Let's move on.
The issue of the children. My learned friend wants that to be regarded as an aggravating factor. It's a consequence. It's a terrible consequence. But it is not per se an aggravating factor of the act of murder, because that presupposes that before the accused strangled his wife, he had the opportunity to contemplate and consider all these sequelae or complications.
Well, now that you've taken us back there, Mrs. Rohde did not die instantly, and a significant feature is that Mr. Rohde did not show hesitation in the commission of his crimes. He did not call for medical assistance. He left her to die.
My lady, I can't answer that any further because, of course, his version of events differs from that.
Well, we've passed his version now, dealing with what I found in judgment.
Okay. My lady, I would in any event submit that taking into account all these circumstances, that the substantial and compelling factors by far tip the scales against the aggravating factors, if there are any. I want to deal with one other final aspect, and that is the purpose of sentence for my client. By rehabilitation, I understand that sentence will place him in an environment where he will learn, and where his propensity to commit such acts will be reduced dramatically or eliminated. In other words, that he won't re-offend. My lady, this is not one of those accused. This man had a clean record till he was 48, and he's not going to offend again, and I don't think anybody would suggest that.
The leading authority says that in serious crimes, even though the elements of punishment includes rehabilitation, that in serious crimes such as this, the aspect of rehabilitation goes to the back, goes to the background. To the forefront comes deterrence, retribution.
Well, my lady, if we look at the aspects of deterrent, punishment, and retribution. Let us not forget that even in terms of the statutory provision, he's going to go to prison for a minimum of 15 years, possibly reduced if the court accepts my argument, but he's going to go to prison. He is going to get a prison sentence. That per se will fulfill the functions of deterrence and punishment. I believe, with the greatest respect, that a just and fair sentence in this case would be something reduced below the minimum period of 15 years. And lastly, it's not always easy to know when sentences should run or be served independently or when they should run concurrently. But my understanding has always been that there would be a tendency to impose sentences to run concurrently in situations where they are part and parcel of the same actus reus, the res gestae.
So,
in other words, in this case, the simulated suicide offence actually flows from the misconduct of murder. And they should be treated, if not as one, for the purposes of sentence, certainly the sentences should run concurrently. The one is interlocked with the other. But if I murdered somebody in Cape Town today and in Durban tomorrow and in Port Elizabeth the next day, those are divorced from one another. If I'm a serial killer, then that's a different story.
on that, on the issue of the staging, I looked at those photographs. It was heinous. Staging of her body, the staging of the scene. There were some strong aggravating features, and I could almost say that it was overstaged. The way Mrs. Rohde is lying naked, the way Mr. Daniels finds her completely naked, there was not a care for her dignity. There was no, I struggled to find in that staging an acknowledgement on the part of Mr. Rohde that this was his wife, the mother of his children. She was just a human being. There was a failure of that acknowledgement.
What the court is saying is that there was a failure to recognize and observe the dignity of the deceased even in her death.
Grotesque vilification.
My lady, I have great difficulty in arguing on this particular point for obvious reasons. I mean, my instructions are that he did not stage the suicide, and my instructions are more specifically that she was wearing a bathrobe at the
I'm
time.
going to go back there. Please can we move from the purpose of sentencing to deal with the conviction?
Well, my lady, if I accept that she was left there stark naked by the deceased, then obviously that did not recognize or respect her dignity. And in that sense, the staging of the suicide was more unacceptable than other, if one can.
More unacceptable
Than it would otherwise have been if she'd been dressed up. If one can talk about acceptability in terms of staging anything. But I cannot really take that argument any further. My lady, those are my submissions. Thank you.
On encouragement, I think we can proceed with your reply.
I'm not going to be that long. I don't have a watch.
It's not 20 past 1. 20 past 1.
I can finish.
May I proceed?
My lady, I think the most aggravating circumstance that I want to stress is the brutality of the murder. I've dealt with it before. He really ensured that she was dead. I'm not going to belabor this point. I can say that in the short adjournment, I did discuss this matter again with Advocate Tennyson, who knows the facts, as well as with Advocate de Kock. And they're both comfortable with the way that I present the argument and my submissions up to now. They support me in that. And may I say, that this is thus not a matter where, as the court already indicated, there's a category in the Minimum Sentence Act, if I could call it that, that already deviates. It's not life imprisonment. We deal with 15 years. And this is my highlight of my submission, that there is no substantial and compelling reasons to deviate from that. What will push it further is the way, the manner, and I'm repeating myself, how she died and all the injuries that was caused by the accused. And it already started, as the court found, when he wanted to leave the room and she tried to obstruct. I'm not going to
the beginning of the wrestling match, as Mr. Rohde called it.
Yeah, it's not.
Just on that note, I don't think I heard my finding regarding the finding of his direct intention to kill Mrs. Rohde. I didn't find that. I found that it was dolus directus, which is, of course, an aggravating feature.
Yes.
It wasn't dolus eventualis.
Yeah, and I refer to that in my head. Yeah. A lot was made about, in argument, how they moved around and bizarre behavior. I'm not going to belabor that. I think it's irrelevant.
Just in reply, please.
A lot was made about his deep, good, warm relationships, but one has to mirror that against his wife, who confronted issues and dealt with issues. He did not. And that caused a huge question mark on whether he is capable of really deep, warm relationships. He shies away from it and he avoids conflict. So
It's his personality, let's not punish him for that.
a lot was made of his depression, anxiety, the effect on the children. He's no longer be able to work for a long time, up to 65. But all of that, my lady, is of his own making. It can't be taken into account as mitigating factors. I think the case law on that is also clear. He created this. He can't go and cry about it now. And in any event, his mother is an example at her age, busy conducting that business, and there's still Mr. Luke given a quarter interest in that. I think we've dealt with the children's finances. I don't really agree with the submissions made there. They were all cared for. And I also referred to the State versus M constitutional case. My lady is aware of the findings there. That speaks for itself. Lastly, I think I want to end off. It is difficult to compare cases, and each one needs to be taken on its own factors. But if you look at the Matetwa case and the personal circumstances of Mr. Matetwa, there is quite comparisons, although he wasn't that successful businessman, but he was a successful
Renowned
musician.
artist.
And a lot of it was similar almost. I don't deny that in the Bizzle's circumstances, as portrayed by my learned friend, it's a pretty good picture that's been painted of him. But despite that, and this is where the Mthethwa case comes in, there was not a deviation from the minimum sentence. Whether the court on the murder itself will find that the aggravating circumstances, I pointed it out, merits a deviation and an increase, that is for the discretion of the court. I'm not going to push that. I think it won't be wrong. If there's up to 18 years on the murder count, and I don't think, I'm comfortable, if I can put it that way, to defend that on appeal, but I'm not going to push it. 15 years, that I feel strongly, no compelling substantial circumstances. Thank you, my lady.
Thank you. Thank you to both counsel and your submissions. Rather erudite. Thank you, Mr. Van Spray, for your very detailed submissions. The court is indebted to both of you. I will take this under consideration. This matter is postponed till Wednesday, the 27th. Mr. Rohde, we'll be back here on the 27th. I'm postponing this matter to that date. I will deliver my judgment on sentence on that date, and I've executed your warrant, and we will date it for your return on that day. Thank you. Court is adjourned.
As the court pleases.